Welcome to businessLine's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hello and welcome to another edition of businessLine State of the Economy podcast. I'm your host, Ayushi. I'm a tech journalist with the publication. So during this winter session of the parliament, India rang in the second of the four planned legislations in the digital tech space, which was the new telecom bill. Another legislation that is in discussion that could impact streaming firms is the broadcasting bill, which is at the consultation stage at present. And we have invited Vivan Sharan, partner at Koan Advisory Group, which is a public policy advisory firm working with some of the largest companies in the world to deliver the client mandates in India, to react to how these bills are going to shape the regulatory ecosystem in India. Hi, Vivan. It's lovely to have you in the podcast.
Hi, nice to be here.
So, Vivan, firstly, I just want to get your reactions to the telecommunications bill. Much of it has been discussed. I mean, it has received, telecom operators have welcomed the bill, but at the same time, you're getting some pushback from experts who are watching the internet OTT space. So, what are your first reactions to the bill?
I think the first thing that I will say is that I think a lot of industry breathed the sense of relief that the telecom bill did not include explicitly within it in terms of the regulatory framework that it tries to create over the top or digital application or content services. In its erstwhile avatar and version that was publicly consulted on earlier in 2022 and 2023, there was mention specifically of over-the-top services, particularly communication services like Zoom and Skype that were earlier defined to be covered under this law and to be regulated under this law explicitly. Now, this final version, which has been notified and is now the law of the land, does not contain references to over-the-top services in relation to being regulated by this telecom law. Why there is a sense of relief because of this is that the telecom law is a specialized law. It's meant to govern the carriage of data, signals, etc. In the pipelines or in the airwaves between transmitters and recipients, whether they be households or businesses and other kinds of institutions. And this is a specialized function. It's very different from governing content of the nature that you may be hearing on this podcast, audio content, video content, messaging content. That is another specialized domain, and it is not currently operating in a vacuum. All of this content, a large part of it, is governed under the Information Technology Act. And so those of us who supported the industry view were cognizant of the fact that if this law created an overlap with another law, it would create some sort of a regulatory confusion, as well as the fact that you would start operating with the logic of regulating the transmission channels or the transmission infrastructure within the content space. So that would again create a very ad hoc and strange situation, which would be unique in many ways to India, where we would apply the logic of regulating something that's completely unlike another thing. So even in the constitution, there is this principle that you have to treat different things differently, different businesses differently. And that thankfully has sort of transferred onto this legal framework that we have now. So overall, a good step. Could more have been done through this law, or could more spaces have been liberalized? Perhaps, but I think the salient feature is its ability to distinguish between content and carriage.
Correct. So, you rightly pointed out that for this time around, it appears that regulation of internet firms, or particularly communication OTTs, has sort of been let go of in this iteration of the bill. But sort of experts and just generally on the first reading of the bill, you can tell that they have kept the possibility to regulate online platforms in the future wide open still. I mean, Mr. Vaishnav has explicitly come out to say that they have no plans to regulate OTT services at the moment. But the fact of the matter is that the government can choose to do that. Like, they still can have discretion on that matter, even in the current space. So I just wanted to get your reaction to that, because it has elicited some concern. from experts who are looking at the internet industry, but do you consider that to be like a serious threat in the future?
No, I don't consider it to be a threat because of two or three reasons. The first is, of course, legislative intent, and who better than for the Minister of Telecommunications to clarify that the intent is not to cover content applications or OTT services within the law. So it's very clear, unambiguous, and if, for instance, some adventurism was seen in this area by a future government, it's a matter of public record that the legislative intent was not to do so. So it would be for courts to judge as to whether the law in the future is interpreted correctly by a future government. Second is there is a, even on a plain reading of the law, even without going into what was intended by the law, why there seems to be a distinction, or why we feel, or I feel that it doesn't carry this kind of threat where content services may be regulated under this law in the future, is that there is a distinction between where any such services that relate to content or content itself, the way in which it has been mentioned is under a definition of messages, which is different from telecom and telecom services. Messages are pieces of data that are communicated via telecom networks. It doesn't form a telecom service or a telecom network or telecom in any way itself. Whereas earlier, when the bill was brought out for consultation, OTT services were brought within the definition of telecom services. So the point is that the distinction between OTT and content applications, which I sometimes will use synonymously, being clubbed under something which is not telecom, but instead it's kind of like the fodder for telecom. Telecom, the end objective of any telecom network is to be able to transmit these messages. The distinction in the definitions clearly brings out that earlier it was sought to be regulated. That was the bill that was consulted on. And basis the consultation responses, which perhaps through an RTI or one day will be made, a matter of public record itself. But we are given to understand that a large part of industry that is not associated with telecom directly did feedback that OTT in any form, whether communications or content, should not be regulated under this law, which is a specialized law, as I said. So all of these factors lead us to believe that even though telecom itself is very broad in its definitional construct, and it will remain as such because all laws that have to do with technology also are trying to simultaneously solve for some amount of future proofing, and that lends itself unfortunately to wide definitions. And this is the case even in IT laws. I mean, for instance, the definition of an intermediary in the Information Technology Act was envisioned in the mid-2000s in India to be broad enough to cover everything from cloud service to even a cyber cafe as being an intermediary between a user and a service available on the internet, or a piece of content available on the internet, which is being delivered through this platform or intermediary. So the point is, telecom is similarly broadly defined to encompass a whole range of technology that could in the future help us transmit messages to each other. These include machines, of course, that there is, in fact, one of the salient factors of this reform was to be able to also envision machine-to-machine communications, which will be driven sometimes by humans, sometimes by artificial intelligence. And to make all of this seamless, you'll have to envision regulatory regime for many of these forms of communication, the regulatory regime does not currently exist. So this law creates the scope for creating some sort of on the basis of some sort of differentiation between technologies, creating different regulatory regimes. So something that would be very high risk or that would run on like public resources like spectrum be licensed, but something that would be lower risk, maybe something operating within our houses like Internet of Things, where machines are talking to each other over internet using telecom and internet services, those may just be required to be authorized under this law, wherein the service provider or product provider goes and registers with the Department of Telecommunication and gives the specifications of their product so that it is known to the government, and there's some sort of KYC, so to speak, of the vendor. So all of that is sort of accommodated within the law. And just going back to your question, this is also the key factors of this law seem, the driving impulses of this law seem to be readiness for the future of telecommunications on the one hand, creating a legal regime for many things that have happened since the last telecom legislation, which was just over 100 years old, creating a legal basis for the several guidelines and notices and things that have been issued in the interim to as a patchwork to be able to regulate telecom, which has truly exploded over the last 15 years, and to some extent solve for ease of doing business concerns as well. There has been some amount of critical attention also given to the increase in surveillance powers and takedown powers through this law, which is of course a cause for concern, but we see this globally, that states are increasingly figuring out ways to increase sort of command and control over the internet, because the surface area of risk has grown quite exponentially. And I don't think states feel very capacitated to deal with those risks without putting in place more control structures.
So absolutely. Just on that point, do you see the kind of interception and surveillance powers or suspension powers that this bill is empowering this government, central and state government with, to be any different from what the general kind of trends towards kind of these kind of regulations are globally? Do you see it to be more draconian in India, or do you think
One of the things that I think, again, scope for improvement is in the future when we have laws that deal with fundamental rights in many ways of citizens to receive information, the right to information in a broader sense.
correct?
When those rights are impinged, whether for legitimate reasons or not, there has to be some sort of a meaningful consultation on the SOP for doing so. Now, in this act, for instance, we don't know what are these guardrails or SOPs that will be prescribed to take down this content, if at all the government executive decides to put those out. And this is actually, I would argue, not a matter for the executive at all. This is something that the parliament should decide on, because it's non-trivial. At the end of the day, you are exercising judgment, and it's very akin to the debate on fake news or misinformation. I mean, who is the final arbiter of all of this? If the parliament feels that the executive is competent enough to be the arbiter of truth or the arbiter of information flows, etc., and whether they're legal or not, then there have to be some guardrails that are also prescribed by the parliament and not dreamt of by the executive. Because ultimately the parliament is the representative of the people, and the people's rights are what are at play here. So that definitely is a area which is a huge scope for improvement in future laws. But overall, do I see there to be a difference above and beyond the fact that we don't know what the SOP is? No.
So lastly, on the bill, on the ease of business doing business front, this bill has been seen to be a fair victory for new entrants into the broadband market. That is your satellite players, because it allows for allocation of spectrum, which is what like Starlink and OneWeb and all these like satellite internet firms were really asking for. And also, like more than that, it allows for administrative allocation in a huge gamut of areas. So how do you sort of see that shift from auction to allocation for certain kind of use cases in telephony or telecommunications, sort of that coming through in this bill? How do you see that for private industry?
I believe that even if the government had not done this, it would have been forced to do this if it wanted to accelerate the pace of adoption of new satellite technologies and machine-to-machine communications in this country. It's simply not possible to centralize this function of being able to manage auction spectrum in such a fine-tuned manner as to be able to deal with hundreds or even thousands of entities that would be dealing with the same band of spectrum, which is effectively what would have happened if it had been auctioned. There is no auction design that will be able to efficiently allocate at one go, in one shot, spectrum to a whole host of players. So for instance, in the case of 4G auctions or 5G auctions, you'd have the main big telcos going and bidding, maybe some institutional actors other than telcos, but it would be limited to a finite set of players, 10 or 15 you can count on your hands, and so on and so forth, and then it's an orderly auction. But when you're talking about something like, say, machine-to-machine communication or even satellite operators, there could be soon, one would like to imagine, there could be tens and hundreds of these operators and thousands and 10,000s of machines that will be communicating with each other. So types of machines even. So managing all of this efficiently is firstly, there is no institution in this country that is capacitated to do so, or anywhere in the world.
Mm-hmm.
And moreover, the global precedent suggests that it would be a highly exceptional measure if you were to start auctioning the spectrum. Every country that has tried it has failed. And
Absolutely.
therefore, you have a body called the International Telecommunications Union that prescribes, or that is a UN affiliated body over 100 years old, that has hundreds of people sitting and thinking about what is the most efficient use of spectrum and which parts of the spectrum or the airwave should you auction as a country and which should you administer. And there's a lot of international coordination that goes into this naturally, because India, the globe the world is turning on its axis, and so if the airwaves are shared, they're a shared resource. So it's very difficult in certain bands and with certain technologies to manage an auction system if you are the only country that is executing it and without harmonizing with the rest of the world. So my belief is that even if we had gone in some other regressive manner to prescribe that everything shall be auctioned, and we want to, our sole purpose in life is to get the most revenues for the tax, for the exchequer from every auction, and not care about how markets will pay us back over time, we would have our backs against the wall very soon, and we would have to have a rethink.
Correct.
So I'm glad that we didn't have to go through that entire painful process.
Absolutely. I just have a few questions on the broadcasting bill. It's still in its drafting process. Both broadcasters and streaming firms have to give their public comments on this matter soon. It seems like they're kind of teaming up together to delay its implementation, citing it to be an onerous regulation in many ways. I mean, quite obviously for streaming firms, there is an increased scrutiny on the content that will come through this bill. But what do you think is the broadcasters' opposition to this bill, and what are the reasons? And when these comments come out from both these from entities like Netflix and Viacom, etc., what do you see that wide gamut of reactions to be to the draft of the bill?
So, firstly, the broadcasting bill is doing something similarly to the telecom bill and something very differently. So because you've talked about telecom, we have a point of reference for the audience. What is similar is that, like telecom, the legislation, they're seeking to define broadcasting very widely so as to perhaps accommodate a whole use of technology, supply chains and use cases and so on and so forth. So envisioning the future and accommodating for it within the legal framework. That is similar in ethos to the telecom legislation. What is very dissimilar is that, like I said, telecom is a specialized legislation. It treats content and carriage differently and defines them differently. Here in the broadcasting bill, they're seeking to club, in the aspiration to be able to create a wide definition, they've inadvertently or willingly clubbed two very different classes, categories of things together. On the one hand, they have broadcasting services, which are basically, again, pipes that carry broadcasted content. And on the other, you have OTT services, which are not pipes. OTT services are content providers. They're akin to what broadcasting organizations are under the global construct of how we think about broadcasting industries. So broadcasting organizations would be of the Zee, Sony, Star variety. So by seeking to do so, it actually confuses the character of broadcasting legislation. So just some background there is that the last time, the current act that we have for governing the cable television space is something called the Cable Television Networks Act of 1995. And the reason for this reform was that in the last 25 years, there's been a lot of changes to the broadcasting space. Again, like telecom, a lot of guidelines, rules, etc. have been brought out without necessarily having legal backing. For instance, there are guidelines to uplink and downlink signals that don't relate to the Cable Television Networks Act, for instance. And the original idea was to bring legal certainty to this space. And then, of course, the construct seems to have evolved to also accommodate for new technologies like OTT services. However, given, like I said, OTT services do not actually transmit data between two entities. They are the ones that originate data, and we as audiences, for instance, we pull this data over telecom and internet networks, which are synonymous with each other. Therefore, there's an intermediary in the middle between users and OTT services, unlike in the case of broadcasting services, which reach us till the last mile in our homes with cable and with satellite and through set-top boxes. These are very different, functionally unequivalent things. And therefore, it creates, again, similarity between very different things, which is a forced way of thinking about this space. And I think industry, in large part, outside of those that actually operate these, that are first operators of these networks, and then sort of have also forayed into content spaces. Outside of these kind of entities, I think you would see most, digital operators, digital service providers actually push back against this bill in not creating a specialized treatment for OTT, which also, again, by the way, similar to the telecom bill, the OTT services are already regulated under the Information Technology Act, which also is seeing its own reform in this upcoming Digital India Act, which is in the early stages of consultation. So it seems premature to do this even before Digital India Act, and it's fully sort of envisioned and brought out. B, it creates, there is a need for specialization, which it seems to ignore. And C, of course, then is the question of rights, like in the case of telecom. Is it furthering the rights of businesses and consumers, or is it reducing them? And that's, similar to the telecom world. It's actually reducing some of the rights that users enjoy, or that businesses enjoy today in the OTT space, by prescribing fairly onerous guidelines or regulations for how content is to be vetted before it is brought out. And also similar to the telecom scheme of things is the fact that, like I said, the SOPs for takedowns in the telecom world have not been consulted on. They're not part of the legislative process so far, and so on, which ought to be. Even here, the broadcasting bill in its current avatar does not specify what content codes, etc. it wants broadcasters and others that are not broadcasters, that I am arguing are not broadcasters, to follow. And without actually putting that out, which seems to be like a substantive element of any form of content regulation, you don't know how you're going to regulate that content in substance. What do you find to be violative of the constitutional scheme of things? Or is it just going to be limited to the limitations on freedom of expression in the Constitution? Because currently, for instance, the Cable Television Networks Act that I referred to earlier has advertising and program codes that regulate content that is available on broadcast on TV. And arguably many elements of these codes go beyond what are reasonable restrictions as articulated in the Constitution. And some of the rationale for doing that is because broadcasters, use public resources and airwaves and so on to reach the user. They don't enjoy the unfettered rights that they otherwise would. But again, here in the case of OTT services require third party or intermediary to reach users, and therefore it's again it's treated very differently from television broadcasting the world over. And here we would be creating some sort of an exceptional treatment of OTT. But where I think we converge with the world in this overall thought process is that globally there is more attention being paid to content regulation on over-the-top services overall, because it is reaching a number of consumers now, critical mass.
Absolutely. I think that's all I had to ask. Thank you so much, Vivan.
Thank you, Ayushi. Thank you.